think we're going to reconvene. I am not doing well in saying how short a break is going to be. I apologize. We're reconvened at 5:20. Mr. Howard, are you ready for item number 9?
Let's call for the vote.
I was trying to see who was just going to step up and... Maybe I should have made it a longer coffee break, but figured to get going. Item number 9.
Right. Good evening, Chair Marcus and members of the board. I'm Andrew Tarianen, an attorney with the Office of Enforcement. Through an unfortunate and a little bit convoluted series of events, I'm kicking off the staff presentation. Mr. O'Hagan's voice is gone due to an illness. So we'll be tagged, Brian Coates and I will be tag teaming on the presentation.
Yeah, you can say all the things you always wanted to say when John was speaking before. This is your shot.
His voice isn't all the way gone.
Right, but
so,
and John can use sign language like
yeah,
that kind of thing.
this slide I won't linger too much on, just because it really gives the headings of all the subsequent slides. But this is the outline of our presentation. Now I'll turn it over to Brian.
Okay, for these first 4 slides are somewhat redundant based on the information that you've all seen earlier today from the presentations by the DWR, USBR, and other agencies. So I'll go through them really quick. On the first slide here, we're indicating that these are 2 pictorial representations of the level of drought, the one on the left being from 2014 in March, and the one on the right being from 2015. The darker the color, the more severe the drought, and as you can see, we're in much worse shape this year than we were last year, with the exception of the North Coast. Every other area seems to be pretty much a darker shade. And this is just a little background information as to the continuing need for the emergency. Due to insufficient rainfall being able to end the state's historic drought, Governor Brown signed an executive order on December 22nd, 2014, extending the California Environmental Quality Act waiver to May 31st of 2016, which consequently extended the board's authority to adopt emergency regulations. To mitigate the effects of the drought and allocate the limited water resources, the State Water Board needs an effective method of acquiring information to address water allocation during curtailment, responding to complaints, and enforcing against unauthorized diversions. Due to time commitments required for pursuing these changes in our normal rulemaking process and the limited window for the current water year, the need for emergency regulations is present. And here you can notice that there's 2 graphs. One is on the Sacramento 8-station precipitation index, and the one on the right is for the San Joaquin 5-station precipitation index, indicating as of yesterday on March 16th, we currently stand at 31.1 inches for the Sacramento 8-station area, and then 13.5 for the one on the right. Too much? Okay.
Turn it back on.
Yeah, turn it back on. Okay. All right. And this is a, it's still doing that to me. So this is just a little bit of background information as well. As of, I don't know, this a couple days ago, we're currently standing at 17% of normal for date. Is it working? I can't hear. Okay. And then there's some background information there for the Sacramento watershed supply forecast and the San Joaquin River watershed supply forecast you can visit. These are the supply forecasts for different levels of exceedance, and as well as a general summary provided by Bulletin 120 at the following address. Okay. Okay, so for the 2014 curtailment effort, our goals consisted of improving the enforcement process with better information, namely refined reported demand, and noting which curtailed post-1914 rights could claim an alternate basis of right. Secondly, providing a level of transparency in our analysis to the public. Through this increased level of transparency, gaining stakeholder buy-in of our analysis through watershed meetings and providing our analysis data willingly. And lastly, providing the public with frequent updates to the curtailment effort and ensuring the effort's effectiveness by enforcing against any party failing to respond to a board order and/or notice. During the 2014 curtailment effort, division staff hosted watershed stakeholder meetings to improve data quality and discuss project operations. Once curtailment notices were issued, we later hosted meetings to discuss a method of lifting curtailments in response to short-term rainfall events. That method of implementing an email notification system was very effective at notifying curtailed parties of a temporary lift and later permanent lift of the 2014 curtailments due to short-term rainfall events. Division staff have also posted our 2015 demand data set on our website as of February, which uses a 4-year average demand versus the prior year's curtailments single year. By posting the demand data set well in advance of any potential curtailments, division staff have contributed to our goal of increased transparency. Currently, division staff are in the process of preparing to host another stakeholder meeting, initially for the San Joaquin River watershed, to discuss potential curtailment. Division staff are also in the process of downloading and analyzing almost 1,000 responses to the most recent informational order for the Sacramento, San Joaquin, and Delta statements. As you know, over 9,000 curtailment notices were issued in 2014. While the 2014 emergency regulations provided the means to issue orders after the notices had gone out, division staff did not pursue this enforceable route due to limited resources already deployed for curtailment inspections. For the watersheds not curtailed but considered in our spring analysis, local voluntary solutions such as those in the Tulare Lake Basin and also lack of supporting information for the Salinas River watershed were found not to meet the need to go by the order route. Lastly, since the 2014 emergency regulations were limited to post-1914 rights, there was no avenue to issue an enforceable curtailment order against a senior right. Of the parties that returned the curtailment certification form, some of the responders claimed a senior right as an alternate source. Division staff looked at a 325 inspection sample size out of the 950 conducted and found 54 claimed a senior right. Of those 54, 20, or about 37%, did not have a statement filed with the division. For these 20 parties, if 2014 was the first year of use under their senior right, they are required to file an initial statement by July 1st, 2015, which currently restricts enforcement of the statement filing law until the summer. Had curtailment orders been issued in addition to the notices for post-1914 water rights, the result would likely have been the same. And then this is just a most recent update of the curtailment certification form response table. It hasn't been much update for the last 3 months, but just indicates the number that are curtailed, the number that have been returned, percent of face value, and so forth.
Can you go back?
Go back. Shoot.
Now, the percent return by face value number is obviously really important.
Right.
The percent forms to return, though, is crazy low in some cases.
Yeah, that column is a little interesting. That's the percent forms that were returned and the amount that was curtailed by face value. So of the amount of the forms that were returned, so of the 40 that were returned, let's say for the Sacramento watershed, the 40% there, how much of that was actually curtailed by face value, meaning they didn't claim an alternate right?
Oh, how much of the 40? That's not how much of the...
Yeah, so that's 7.3%. So percent forms returned and diversion curtailed by face value. So of the 40% that were returned, that represents 7.3% of the actual face value that was actually curtailed, meaning they actually stopped and they didn't claim an alternate basis of right. So some of those were claiming a senior right since their post-1914 right was curtailed. Mm-hmm. So in that event, yes, their post-1914 right was curtailed, but the actual amount diverted they're still diverting it, but they're doing it under a senior right.
But wait, but that's just the percent from the ones that return the form.
Yes.
What about people who didn't return a form?
We don't have that information right there. But we can compile it, I'm sure, yes.
Well, it's just apropos of the enforcement conversation we keep.
Yeah, there's always been a lot of questions on that last column. It's kind of interesting, but yeah. Okay. Okay, and late last year, division staff issued 23 informational orders to parties downstream of Friant Dam as a result of a complaint filed in May of 2014. Enforcement action has been taken for failure to respond, with additional actions for failure to respond and threatened and/or unauthorized diversions are pending. Of the informational order recently issued in February 2015 to the top 90% of Delta statement holders and the remaining top 90% of the Sacramento and San Joaquin River statement holders, we have received, as of a couple of days ago, over a 94% response rate, with the preliminary results shown in the following graphs.
Now that's a number.
That's pretty good.
It's a number.
I like it.
Yeah.
Okay, so this, again, on the, this is the actual amount of water that we were using on the left there, the brown or red, whatever if you're colorblind or not. So that's the 2010 to 2013 4-year average demand we were using for curtailment analysis up to the informational order. And so you can see there's 5.2 million acre feet, or 5,254,000 acre feet, that we had planned on being consumed for the Sacramento, San Joaquin, and Delta statement holders. After compiling the responses to the web form from the informational order, we noticed a reduction for 2014 reported diversions of about 23%, down to 4 million acre feet. So that's already a 23% reduction in demand just from the informational order results we compiled.
Not a reduction in demand. It means that it's trued up the numbers that we would be relying on versus our estimate.
Right. So in our
It's an important reason to have the information.
Exactly.
Right.
That's the reason why that's the benefit of the informational order is prior to that, those results coming in from the informational order, we would have utilized the 5.2 million acre feet number for demand, which would have unfortunately caused us likely to curtail people that didn't need to be, because the 2014 demand is showing a lesser number. And then the 2015 in green is the projected diversions. So it's a little bit less. And so that's the April through September summary. And we go to the next graph here, and this is the monthly distribution, because again, when we requested that information from the statement holders, it was by month. And so we graphed this to show that as well. So the top curve there representing the 4-year average demand we were initially using, the blue curve representing the adjusted 2014, and then the green what they plan on doing this year for demand. And so that's going to help everyone, because we're not going to need to curtail down to a certain level or curtail at an earlier date in the absence of that. Yeah, and that's another issue there is we, that 94% reporting as of March 12th, but most of that data was due on March 6th, so we've done the last week and a half of compiling that.
And on roughly on face value, so 94% of the parties. And
it's 94% of the statement holders. So we sent that out to 1,061 statement holders, and so 94% response rate. And so we're only tallying up the 94% that responded in comparison to the 4-year average demand.
Okay. So
It shows a peak in, oh, I'm sorry.
Go ahead.
This shows a peak in May and then a decline in June and July. Doesn't that seem a very odd pattern, especially if it's principally irrigation water?
Yeah.
And some of that might include storages. And so again, this is just the rough summation of the submitted data. There's additional comments that we haven't had time to actually compile yet because it's only been less than 2 weeks, but this is just the initial results.
And I guess it was my understanding that last year in 2014, crops came in earlier because it was so hot, and so you might have had a decline because they were just harvesting rather than watering. Well, not in May, but when you get out to July.
I think actually the storage answer is sounds correct to me. But thank you. Sorry.
Okay, at this point, I'll hand the presentation over to Andrew.
Thank you. I'm going to get into the nuts and bolts of the proposed emergency regulation. First, I want to just mention briefly what the existing 879C does, the one adopted last July. 879C, the current, allows informational orders only against pre-1914 and riparian claimants, and only in two limited conditions. One is whether when there's a complaint received alleging an interference with a water right by that type of claimant, or two, when the division receives information alleging unlawful diversion of stored water. So it's a very limited tool for gathering this type of information. The proposed emergency regulation expands this authority. It makes it a more useful tool for the purposes that we're proposing it for. Let me talk about what it is. It's an enforceable tool to investigate complaints alleging interference with a water right by a water right holder, diverter, or user. And in that sentence, and this is the way it reads in the resolution. Oh, and also, you've probably seen, but the first page of the digest has a red line version, or strikeout, bold, underline, and strikeout version comparing the proposal to last year's, because the changes are fairly significant. But in the first sentence, in the first bullet point, the interferor is the water right holder, diverter, or user. The complaints don't have to come from those parties. So also, in circumstances where parties claim previously unasserted senior rights in response to an investigation or curtailment, which we did see last summer and last fall during the inspections on the curtailment notices. Also, in response to parties claiming unverified and previously unnoticed transfers or contract purchases. What we mean there is when a party claims, instead of a senior right, they say, I've purchased or I've received a transfer from somebody claiming a senior right. And this would allow us to verify the underlying status of the right. And then finally, in circumstances where there are threats of waste or actual waste, unreasonable use, unreasonable method of diversion, unlawful diversion of water by any water right holder, diverter, or user. So in any of those circumstances, that last slide was the triggering conditions. If any of those conditions are met, the deputy director may issue an order requiring information regarding a claim of right, property patent date, date of initial appropriation, and diversions made or anticipated during the current year. Those are all more or less in the current version of 879C. The last two bullet points, compliance with transfer law if the diversion is not subject to approval of the board or Department of Water Resources. Again, that's a paraphrase of what's actually in the section, but the intent there is to allow us to gather information regarding the right underlying any approval or any transfer or contract purchase if we didn't already know about it. And then finally, any other information relevant to authenticating the right or forecasting the use and supplies in the current drought year. So why do we need this tool? This allows the division to focus information gathering into really two categories. The first is investigations and enforcement in response to complaints, curtailment notices, and allegations of waste and unreasonable use or unreasonable method of diversion. And then also, as Brian has noted and shown, to address curtailment decisions and to use the information gathered to help refine the curtailment decisions. An important distinction is that the proposed regulation does apply to post-14 water rights as opposed to just pre-14s and riparians under the current version. And then finally, that we can and almost certainly will require reporting on water use and compliance with any curtailment notice if there's a information order issued in response to a curtailment notice or a complaint that involves a curtailment notice. This kind of regulation, this kind of information tool allows us to get better information faster. It is important to note that as a regulation adopted under the drought emergency provisions of the Water Code, it becomes immediately enforceable. That is, a party who doesn't respond or who wholly inadequately responds could potentially be subject to enforcement immediately. There's a $500 per day provision going directly to administrative civil liability for that kind of violation. But the penalties or enforcement can also take place under the sort of standard enforcement provisions of the Water Code. That is, start with a cease and desist order and then go into ACL's administrative civil liabilities for violations of the cease and desist order, or administrative civil liability for unauthorized diversion. These, the orders themselves won't necessarily cause these kinds of enforcement actions, but they will help bolster those cases. And finally, better information aids enforcement and helps the board to more quickly and accurately refine curtailments. A couple slides about the fiscal impact analysis. This is Appendix 10 of the Regulatory Digest. As you're aware, the analysis is required by the Office of Administrative Law to examine the effect on state and local government, federal funding of state programs, and the analysis does not require a broader economic impacts analysis. It's just impacts on public agencies. So here the government agencies we've identified as being potentially affected are public, agricultural, and municipal water agencies, and state and local governments. The cost to water agencies associated with the new certification form, again, we were anticipating that the type of form that was used under the recent information order, the one that was issued in February, would apply to any new information orders issued under the new proposed regulation. And that form is essentially, it's a web-based form that you fill out, and then in some cases where there needs to be further justification of the basis of the water right claimed, that information gets emailed in. So we've estimated the time we think it would take for public agencies to comply with this form. There are 2,483 diversions owned or controlled by public agencies in our records. Of those, 2,058 are post-14 water rights, so they're permits or licenses. In those cases, those agencies would not have to submit the backup information to support their claim of right. That's already on file. So for them, it would take, we estimate conservatively, about an hour to gather their diversion data, because that's information they should be collecting along the way anyway, compile it, and then submit it. For riparians and pre-14s, there are 425 riparians and pre-14 claims controlled or owned by state and local governments. They have the 1 hour to compile their diversion data and submit it on the form, but they also need to gather the underlying supporting information. We've estimated that, conservatively or roughly estimated that about half of the agencies will have that information somewhat easily obtainable, meaning they can obtain it within 3 to 5 hours of staff time. In other cases, they may take them a lot longer, so the other half would be up to 24 hours of staff time to gather the information. We average that out to 15 and a half hours total compliance time for those 425 diversions. Multiply all of the hours that it would take for each of these diversions by our estimate of $65 an hour for a staff engineer. It's the same estimate used in last year's fiscal analysis for the previous version of this emergency regulation. And the total fiscal impact or the costs statewide, and it is important to note, this would assume that every state agency's diversion receives an information order, which I think is a very, very conservative estimate, is $561,958. The curtailments and related costs are not affected by these information orders, and in our examination, there's no effect on state or local government or on federal funding of state programs. There's one, we didn't do a change order for this, there's one small typo that occurred in between, well, it occurred in between the agenda notice that went out about 10 days ago and the digest that was posted about 4 or 5 days ago. One letter of one word of subsection C1C was changed, and you can see in the very end the word has was changed to had. So that's the correction. Again, we don't have a change sheet, but we're going to propose that, we're going to recommend that the board adopt the resolution as presented with this correction. The next steps, this is repetitive of the staff presentation from the prior item. This is just the OAL process. We are hopeful that the regulation can go into effect in early April. The current version of 879C expires on April 14th. It goes through April 13th. And then it would last for 270 days. That last point about when the regulation expires is relevant because a number of the commenters made comments about the status of Section 879C. The comment deadline was extended until yesterday at noon. We received about 7 comments. We did list them, but I haven't been able to tabulate what the comments are into a slide. I can briefly note what the main comments are, the ones that are shared by several commenters. The first is that that the 30-day time limit might not be enough when it's necessary to gather information to support the basis of a right. We found this to be a common theme of the responders to the February information order, and so the proposed regulation, it's C3, allows the deputy director to grant additional time beyond the 30 days upon a showing of good cause, and if there's substantial compliance with the rest of the regulation requirements, meaning if they can submit what they have, and that especially means the diversion data, which should already be present. Most agencies should already have that, or most diverters. The second comment is that Section 879C actually expired on February 28th. A number of commenters, local agencies of the North Delta, Restore the Delta, San Joaquin Tributaries Authority, and Spoleta Law all made this comment. There may be others that I'm forgetting. It's Harum Crabtree's comments, the Banta Carbona. The 879C was adopted in an emergency regulation that was approved by OAL on July 16th of last year. So it doesn't expire until April 14th. April 13th is the last day it's valid.
So counting from the date of adoption rather than OAL approval?
No, they're counting from the date that 879 initially was adopted under last year's version of the fisheries regulation, and that did expire on February 28th. But 879C was added in July with the statewide curtailment order reg. Did you?
So, yeah, briefly, the initial package that the Mill Deer and Antelope Creek package that the board just heard about was initially adopted last year, I believe May 21st, and that included a number of sections in brand new Article 24. One of those was Section 879. It only included subdivisions A and B, which were reporting requirements for anybody who received a curtailment order. This item, the statewide curtailment and informational order item, was presented to the board and made its way around about a month later, and 879C was added at that time. So while it's true that
We didn't do everything on the same day last year.
we did not, 879A and B have in fact expired, except that the board readopted them an hour ago. They haven't gone to OAL yet, so they are not on the books. But 879C is not floating out there in the ether. It does still exist and will until April 14th, when it would expire after 270 days.
And then the last sort of general category of comments, there's a number of comments that I'm gonna skip. I see that most of the commenters are here, and they'll probably bring up some of the specific ones. But the comment that I think was most common is that the regulation should define the term complaint as it's used in Section C1A. And again, the language there is it's a triggering condition for issuing these orders upon receipt of a complaint alleging interference with a water right by a water right holder, diverter, or user. The term complaint has its commonly understood definition, and the board has always used it that way. There is no specific definition of complaint anywhere. There is a section in the Code of Regulations addressing complaints alleging certain types of harm caused by violations of permit and license terms or conditions, but that's really more of a form and process requirement. Broadly speaking, there's always been a complaints unit in the Division of Water Rights, and there still are staff that receive complaints. There's a direct phone line for phoning in verbal complaints, and there's no format requirement there. We get complaints from a number of other vectors, notably the Cal EPA website, and again, that's just a simple web form that alleges complaints. So,
But isn't it a piece of what some folks want is they want it's almost like a standing argument?
yeah,
They
that's one.
wanted the complaints to only be from another water rights holder as opposed to anyone else?
Yeah, that's one of the other comments, that standing as a water right holder or standing as a water right holder who's been harmed. I think injury and standing are sort of conflated. And that's never been a condition that the division is required for investigating complaints. And I think it's evident in the fact that the division investigates complaints alleging public trust harm, waste and unreasonable use allegations, and complaints that may have no definitive source at the time the complaint is made. My stream went dry. I don't know what caused it, but maybe somebody upstream is doing that, is causing it. But you know, the complainant at the time can't point to specific injury caused by a specific diverter necessarily. So, and then related, I'll go a little further in this concept of complaint, because a couple of the commenters have proposed language to the effect that staff, that the division should make a determination that any complaints that are issued are reasonable and substantiated. Another one of the proposed languages is that the complaints meet a minimum standard of evidence to support a claim of unlawful diversion. Staff does these kinds of examinations for every complaint that's received. If a complaint comes in and has no basis, no substantiation through staff's own investigation or based on what's received, then the complaint goes no further. But if there is some basis for it, investigations can occur for a very long time. I'm one of the attorneys now who helps shepherd those complaints through those investigations through their process. So I would say those proposed changes are unnecessary. We've hit most of the main comments. I don't, unless the board would like, I don't necessarily want to list right now all the specific comments, because I think we're about to hear them, relating to, you know, the concept of water rights in the Delta or water availability in the Delta, for a couple reasons. One, we're about to hear them, and two, a lot of the issues are raised in petitions for reconsideration of the Delta, or of the statewide San Joaquin, Sacramento, and Delta information order that was issued in February. It's order WR 2015-2-DWR, and I don't necessarily want to go too deeply into any of those matters that might be subject to the petition. At this point, that concludes the staff presentation, and we'll take questions now.
Questions now? All right, well, let's move into the comments, and you'll be around. Thank you very much. First, we have John Rubin, San Luis and Delta Mendota Water Authority. Thought you'd be last so you could open and close. Someone thought you wanted to do that, but here you are on the top of the pile. What can I do?
After your reaction to my comments this morning, I'm happy to be before you.
Oh, you did. A little pushback there. And he's followed by Tim Strachane.
Good afternoon, Madam Chair,
Hello?
members of the board. John Rubin, General Counsel for the San Luis and Delta Mendota Water Authority. And I do have just a brief comment for you. The Water Authority believes it's important that the State Water Board be prepared to exercise mechanisms or a mechanism to stop diversions that are causing a trespass on the waters of the state. And because of that, I do want to highlight what's not before you today. Last year, when you were faced with this question about action to stop diversions that are illegal, there was discussion about the mechanism that you currently have, or the mechanisms that you currently have that are set forth in the water code. And there was also discussion about supplementing that. And last year, staff had proposed a regulation, an emergency regulation, and through discussions with the board, ultimately the board adopted something, but it was different than the staff's proposal. I believe it was codified under Section 875. That regulation or something similar to that regulation is not before you. I stand today not to recommend a particular course of action, but just to highlight how important it is, given how dry conditions are, that you do have a mechanism that would allow you to act very quickly to stop illegal diversions. From my understanding of the water code, if you do not adopt an emergency regulation, you really only have one mechanism available to you, and that's under Water Code Section 1052, and specifically it's a referral to the Attorney General. And so with that, I have nothing further, but again, just want to stress the importance of being able, you being able to stop illegal diversions if they do occur.
Thank you. Agree. We're not foregoing an ability to come back later, but I think getting the information first and foremost and deal with this is going to put us in a better position to decide what to do. But good point.
Thank you.
Tim, followed by Kyle Jones from Sierra Club. Will you say your last name again? I say it wrong every time.
Oh, it's just, there's no accent to it. It's
Stroshane.
Stroshane.
Okay.
That's how I've always heard. It sounds funny to say it other ways. So,
Okay.
Good evening. We've made it to the evening already. I'm Tim Stroshane, Policy Analyst with Restore the Delta. Our organization submitted comments yesterday morning, and I will summarize some of them. Drought emergency regulations may come and go, but much of the data that the board collects through its information order should be useful beyond just constructing this year's demand curves. And we encourage the State Water Board to address the paper water issue for all Central Valley water right holders, perhaps not now, but in the future when there's more time perhaps. And the California, that you would address this issue for all Central Valley water right holders and the California public that cares about the state's rivers and streams and the natural heritage of the Delta. Paper water is the practical reality that there are far more water rights claimed to use water than there is actual water available to allocate, especially, of course, during droughts. Since 8 of the last 9 years have been below normal water years, it may be that in the era of climate change, California enters a new normal. We urge the board to ask and hopefully answer questions like, if water right holders have riparian or pre-1914 rights, and also post-1914 rights, do they really need multiple rights? There may be a basis for it, I don't know, but, and the board would need to investigate that, but it's a question that I think you should be asking. What is the status of claims? The second question is, what is the status of claims against which enforcement actions are applied? Are those claims to divert water extinguished permanently by board action under emergency drought regulations, or are enforcement actions merely in effect while the emergency regulations are in effect? Third, what due process and equal protections must the board apply to permanently eliminate redundant water rights once they are identified? Another question is, if the State Water Board believes it obtains meaningful information on demand and supply, could and should the board encourage the Department of Water Resources and the Bureau of Reclamation to better plan their operations to fit that new normal better than they do now? By doing so, couldn't the multiple objectives of reservoir operation for water supply, temperature control, and salinity and water quality control in the Delta be planned before exports are determined. I've done research into these sorts of questions, but I don't know the answers to them. I'm not sure that you do either right now. But it seems to me that answers to such questions may help reduce confusion and increase reliability of water rights found valid by the board. By reducing confusion, the board can help reduce the claims of so many chasing so little water during California's droughts, today's as well as tomorrow's. Other Western states have done much to accomplish something similar. Reduced water demand would benefit public trust resources, including listed species in the Delta, whichever ones still exist. The Delta Protection Act of 1959, I'll conclude, states that it is state policy that no person, corporation, or public or private agency, or the state or the United States should divert from the channels of the Sacramento-San Joaquin Delta to which the users within said delta are entitled. Finally, the Act also says that in determining the availability of water for export from the Delta, no water shall be exported which is necessary to meet the requirements of the Act. And I want to thank you for the opportunity to comment.
Thank you very much. After Mr. Jones, Tim O'Loughlin, or Valerie Kincaid.
Good evening, Chair, Board. Sierra Club, California, with Kyle Jones with Sierra Club, California, and we'd like to show strong support for this measure. Information pertaining to rights that prior to 1914 and riparian rights is critical to helping us understand exactly what we're dealing with, what resources we have going forward through this drought, and however long it may last and for future droughts. Again, strong support for this. Thank you.
Thank you, Mr. Jones. Valerie Kincaid, followed by Rebecca Eckroyd from Westlands Water District.
Thanks. Valerie Kincaid, San Joaquin Tributaries Authority. The San Joaquin Tributaries Authority submitted comments, and I'm not going to go through those. It's late. But I do want to go through the issue of the finding of emergency and focus on that. There were significant changes from the previous version to the new proposed version, and the finding of emergency doesn't explain the need for those changes, and it doesn't explain why those changes are needed in an emergency context, which I think is very important. And it feeds into my second point, which is that it'd be very helpful from a stakeholder perspective to understand what the State Water Board and the State Water Board staff plans to do with this information. It's the #1 question I get from clients all over the state is, why are we submitting this? What are the next steps? And unfortunately, there's not a good answer. I've talked to staff a little bit about that and have gotten somewhat vague answers. And I think that frankly feeds back into the emergency context. The State Water Board just asked, and my understanding is received from the presentation today, volumes of information. If it's not going to ask and receive and look at volumes of information from this now proposed change regulation in the next couple months, it's not an emergency. You don't need it. So if you are, that's great, but it has to be part of a bigger plan, and it'd be really helpful for stakeholders to understand, not only just for them to feel comfortable, but for their due process rights, if this is going to lead to an enforcement action, if there's an adjudication down the road. And I understand that you might not have all of that figured out right this second, but there has to be a greater plan of why you're just collecting the information. Certainly collecting this information just to collect it and not do anything with it also probably can't be an emergency under these regs. So we have the technical comments, and I guess my plea maybe would be just to work with stakeholders and ask them for this information. Most of our clients, if you go and ask and say, hey, listen, we're unclear about the basis of your right, can you provide us this information in a non-threatening and a non-enforcement context, they'd be much more willing to do that. I think, unfortunately, this round of emergency regs has put people a little bit on the defensive. They feel like they're having allegations thrown at them. And then the second part of it is that they don't really understand what's going to happen with these allegations. So, you know, from my perspective, this caused quite a bit of confusion. and maybe from your perspective, more panic than there needs to be, since maybe you guys either have an understanding of what you would or wouldn't do and have a greater plan. But the stakeholder community doesn't understand that and hasn't been given enough information to better understand that. Thanks.
Thanks.
Well, I think, well, first of all, I think the digest, as well as the presentation you heard from the division staff and then also from Mr. Turanian this morning, goes through a number of the reasons why the division may be interested in using this information. It's important to appreciate that until an order is actually issued, there hasn't been a finding, if you will, as there is in the context of a specific order, that there's a basis for that specific request to the diverter. However, in the context of the regulations and the types of information that the board is interested in gleaning, some of it may be just for purposes, as Mr. Turanian explained, of determining whether or not there is an appropriate basis for the diversion, and that could potentially lead to a subsequent enforcement action. And likewise, as you heard in the presentation earlier this evening, it is used to feed into our overall demand curve, which informs the board's drought response. I mean, this is a recurring theme that you all have heard over the last year, which is the board's inability to, or the board's lack of sufficient information to respond to the drought and make the determinations about whether or not curtailment needs to be turned on or off. And you see these regulations as part of an approach to ensuring that if we get to that point later this year, we will have tools to issue informational orders or take other enforcement action as appropriate.
Well, in a timely manner so that it might matter. Also, in the hopes of resolving some of the long-held, I would say, rhetorical badminton matches that have gone on. I think our goal is to try and resolve issues in as timely a way we can. Some of them we won't be able to resolve immediately, but the first basis of it is being able to have information, which we don't have at our fingertips for a variety of reasons. So.
Yeah, thank you for that. I think that in some ways, you know, the comments we received, we respect that concern because things are happening quickly in the emergency context. At the same time, I hope you can bring back to your clients and folks in the room that staff did turn around a summary analysis of the information we received in a very rapid fashion. You saw a graph in terms of the refinement of what we had to use based on 2010 statements of diversion and use versus the information we received in the last couple of weeks and how that's changed our assumptions on demand management, and that will feed into our determinations of what water is available or has to be curtailed. So we hope that this gives you an example of our very firmly held goal, I believe, I'll speak for myself, of an orderly administration of water rights, especially during a drought emergency. And you know, this is where our system gets